Hello, welcome back to Brand Institute of Forensics and Security. I will, as usual, we say hello, we say jambo, we greet each other, we appreciate each other. There are people who start training each other or talking to each other even without saying hello. It's not a very good practice anyway. Today, we are going to talk about CCTV courtroom best practices. CCTV courtroom best practices. And this is another lengthy presentation, and I will encourage you to take notes in a very short format. However, we are going to arrange notes for you. So I will only encourage you to note down things that are very, very, very important. Things that you think you need to remember or you need to research more on. I'm going to start this topic straight away under CCTV surveillance. And we are going to, first of all, look at what is CCTV digital evidence. For sure, we cannot start talking about courtroom best practices without an understanding of what is CCTV digital evidence. So I want you to think about it. What is CCTV digital evidence? What are we talking about when we talk about CCTV digital evidence? The forensic analysis of CCTV footage can assist in identification of individuals, vehicles, time of day, or determine the timeline for a sequence of events. Experts will rebuild the video footage, ensuring it remains true to the original content using specialized software, equipment, and recovery techniques. This ensures the video and the CCTV evidence is extracted, reviewed, and presented following set procedures and in accordance with the best practice guidelines. So in short, when we talk about CCTV digital evidence, we are talking about extracted video footage that is extracted from a CCTV surveillance. It could also be still capture of a photo extracted from CCTV systems, or it also could be an audio recording extracted from a CCTV surveillance system. This is what we mean by digital CCTV evidence. What we mean by digital CCTV evidence. Now, what is CCTV forensics? Let's look at the basics before we can go into our main topic. What is CCTV forensics? CCTV forensics refers to the use of still and moving images from a CCTV system that has single or multiple cameras attached to it. This refers to the use of still and moving images from a CCTV system. The expert will capture all footage within the period of interest from as many CCTV systems or cameras as possible. Once all available footage has been reviewed, the expert will put together the relevant footage for presentation along with a report and statement. Where are we representing this relevant footage? To law enforcement and also to the judicial system, and specifically the court. They will identify specific information relating to the investigation, along with times and dates from one or more of the CCTV systems. This evidence can help both prosecution and defense in establishing the true cause of events in a case. The do's and don'ts for making a video evidence admissible in court. The do's and don'ts of making a video evidence admissible in court. To get someone convicted of a crime they are guilty of, it's imperative to follow protocol in submitting CCTV evidence in court. Something has happened, something is under investigation, it is a criminal offense, it has to be prosecuted in court of law, evidence is required. You as a CCTV surveillance officer, you're supposed to submit this evidence to the investigating officer who's from the law enforcement, and the law enforcement will use this evidence in court of law to prosecute someone and to have that person convicted of the offense they have committed. Therefore, there may come a time you as a CCTV surveillance officer, you are required in court of law to talk about the evidence that you submitted to law enforcement to prove its authenticity, to prove its integrity, to prove that it is what was recorded and observed and retrieved by you from the system. Those who find themselves presenting digital evidence in court are up against a lot of pressure. And it's easy to get caught up in the pitfalls, some of which could render the evidence inadmissible and thus cost you the case. When we talk about inadmissible, it means the evidence has been rejected by the court. The judge or the magistrate finds the evidence to be not relevant to the case. Thanks to the advancement of technology, many CCTV can now capture detailed footage without costing an arm and a leg. Therefore, video evidence has risen in prevalence, and numerous court proceedings rely on it to determine the outcome of cases. But with different providers comes the challenges of specific file formats, preserving the authenticity of the recorded footage, and a myriad of other hurdles you'd best get acquainted with in advance. The fact is that video evidence is estimated to play a role in 80% of crimes. Examine key differences between admissible and inadmissible audience and lay out the best practices. Video evidence, in most cases, especially in this age, you find that the court relies a lot on video evidence to prosecute cases and to convict offenders. Now, let's first go back and look at 4 basic types of evidence. And when we talk about this basic type of evidence, think about CCTV evidence, which is a recorded video footage or still image extracted from CCTV systems. For evidence to be considered admissible in court, to be considered admissible is to be accepted in court. It needs to establish a fact and be relevant to the case. The basic types are as follows. Demonstrative evidence establishes a fact, e.g., video evidence may display footage of a person breaking into a vehicle. It demonstrates a crime has taken place, as well as the circumstances surrounding it. 2. Testimonial evidence. Testimonial evidence involves a witness who may be summoned to the court to recap the events of a crime that has taken place. And then we have documentary evidence, any type of document that is relevant to the case, e.g., this may be a contract of employment, e.g., or any signed contract between 2 parties. This is what you call documentary evidence. And then we also have real evidence is an object relevant to the case, e.g., shades of glass, a murder weapon, etc. Therefore, CCTV evidence is in the group of demonstrative evidence. A video evidence may display footage of a person breaking into a vehicle. It demonstrates a crime has taken place as well as the circumstances surrounding it. Please write something down. Write demonstrative, testimonial, documentary, and real. And then you can note somewhere that CCTV evidence, digital evidence, is under the category of demonstrative evidence. Video evidence falls into the demonstrative category because it accurately retells the story of what happened, step by step, picturing every relevant detail. It is used to establish a fact. Can CCTV footage be used as evidence in court? And the answer is yes. CCTV footage can serve as evidence in court for proving someone was at a particular location or for proving that a crime has been committed. Video or audio recordings, e.g., surveillance footage, Zoom meeting recordings, photos or screenshot images, e.g. photo of harassment incident taken by a bystander may be used in court to prove somebody committed a particular offense and have this person convicted by the court. An example is what we can see on these photos. You see that number one photo, somebody is walking along the street. Let's assume it is Tomboya Street or Johannesburg Street, and some person is walking along the street, then another person is following him. This person gets very close. Now this person assaults this person. Now this person assaults this person and takes maybe his mobile or money, and then this person takes off. So if the sequence of this event, this footage is presented to the court, and the video is of high resolution, it is clear, and we can prove the authenticity and integrity of this particular video, then it may be used as evidence, demonstrative evidence, to convict the person who is escaping the scene. This is just an example for you to think about when we are talking about CCTV recorded footage, and this is how we may piece the pieces together and have somebody convicted in court of law. Evidence may be ruled inadmissible if it is. Now, we say inadmissible is evidence that is rejected. So even a video footage may be rejected by the court. A still image that you have presented may be rejected by the court. Number one, evidence may be ruled out inadmissible if it is hearsay. If a witness retells the story of what someone said outside of the court, their words may be difficult to prove. Although hearsay is generally inadmissible in court, there are a couple of notable exceptions to the rule. Unfairly prejudicial. Inducing a jury's outrage by presenting gruesome video footage that adds little to nothing substantial to the case is often excluded. Inducing a jury's outrage by presenting a gruesome video footage that adds little to nothing substantial to the case is often excluded. Remember, evidence must be relevant to the matter in question for it to be admissible in court. If it is not relevant to the matter in question, then directly that one is inadmissible. For example, we are investigating theft from a particular finance store, and then you submit a video of people sitting in the canteen eating lunch, that it is not in any way touching to people accessing the finance office, then that one is clearly irrelevant to the matter in question. Privileges. If testifying would make the witness break an oath, for example, a doctor or a priest being asked to reveal something shameful or confidential about an individual that was entrusted to them, the evidence may be ruled out. So privileges. Evidences basing on privileges may be ruled out. This, however, is a complicated area of the law. Under certain circumstances, a right not to testify can be waived. And then, if the evidence wastes time, definitely it will be excluded. A fact does not need to be established multiple times. If the evidence fails to bring anything new to the table, it can be seen as a time waster. It can be seen as a time waster, and it can be excluded from the court as evidence. Now, expert testimony may also be excluded. While an expected testimony can be admissible, in case the witness fails to present the qualifications necessary, it can be ruled out as evidence. In case the witness fails to present the qualifications necessary. For example, you say you are a document examiner and you are submitting a document to the court to be used as evidence. If you are not qualified to examine documents, if you don't have any qualifications, certifications, that is why we encourage security officers and CCTV surveillance officers to go further and acquire certifications. Certifications ensures that you are qualified, you can do the job according to the law, and you have the qualifications. So, evidence that a witness fails to present the qualifications necessary, it can be ruled out as evidence. And then character evidence. In case a legislator attempts to establish that the defendant has certain character traits, and that the defendant has acted according to those traits, this kind of evidence can be considered inadmissible. And then misleading evidence may be ruled out when it attempts to draw a false correlation or tries to build a case that's based on assumption. Instance, the defendant may belong to ethnic minority, but alone does not necessarily make them prone to violence or to criminal acts. Those are some things that we need to. Misleading evidence based on prejudices, based on racism, based on sex orientation. These ones are usually not admissible in court of law. And then we also have to look at, let's turn our attention to what makes the difference between video evidence that is admissible in court and one that isn't. We started from looking at admissible evidence and inadmissible evidence as a way of laying the ground. But before you go to court, before we talk about courtroom best practices, you must be able to understand what is acceptable and what is not acceptable in court as relates to video evidence. Admissible evidence is the only kind of evidence that can be taken into the equation when determining the outcome of a case. After all, the goal is to bring the truth into light, and to do so we need facts, not assumptions or unverified information. So you as a CCTV surveillance officer, when you are retrieving this evidence, I think you need to understand that there is a separate topic that talks about retrieval, preservation, integrity of evidence that can be admissible in court. When you are retrieving this evidence, you must make sure that you are not basing your conclusions on assumptions or unverified information. It must be something that proves whatever is being questioned. The mantra is to prove something beyond a reasonable doubt. As such, the evidence presented needs to meet certain criteria and standards. Otherwise, it can be deemed inadmissible and is effectively ruled out of the equation. Remember, it doesn't bother very well, it doesn't look well on you as a CCTV surveillance officer or a security manager to present evidence in court or to present evidence to law enforcement officers, and then the evidence is used in court, and then the evidence is ruled inadmissible. That one touches on your integrity, on your competency as a qualified security manager or as a qualified CCTV surveillance officer. If evidence is considered inadmissible, what are the consequences? What is the repercussions if evidence is considered inadmissible? This means if evidence is not acceptable in court, or if evidence is not accepted in court, what are the repercussions? This simply means that the evidence presented cannot be used in court. Simply means that the evidence presented cannot be used in court. 2. Inadmissible evidence cannot be used to prove or disapprove a fact and is essentially irrelevant to the case. Number 3, a digital video forensic analyst must pay close attention to the protocol and follow it diligently. For a criminal trial to result in a conviction, it is essential for law enforcement personnel to closely collaborate with the prosecution. So it is very, very important. It is very, very important that the evidence that you present in court is admissible. Otherwise, if evidence is inadmissible, it means the case may not be acceptable in court, and you may end up setting free a guilty person who has committed a serious criminal offense. Is video evidence enough to convict the defendant? That is a question that we have to ask. As long as the evidence is admissible in court and provides incriminating proof, the answer is generally yes. However, it must provide answers to several questions, including the identity of the person on the tape or video and what crime has been committed. At the evidence time, the video forensics examination must rule out the possibility that the footage in question has been tampered with. So we are talking about chain of custody. In addition, it must not be altered with forensic video enhancement that utilizes artificial intelligence technology. Test it runs the risk of being deemed inadmissible. So the video must not be altered, the video must not be tampered with, the video must have undergone a thorough chain of custody. We are going to talk about chain of custody shortly. Making video evidence in court admissible. How to make your video evidence in court admissible. You are a surveillance officer, you are working at a particular facility, and something has happened, and you have the video that you need to give to law enforcement to follow up on a particular case. How do you make the video evidence in court admissible? How do you make sure that it is admitted in court? The do's and don'ts. How to prepare and present video evidence in court. Now we're talking about the best practice. Number one, do prepare your material in advance. Never enter the courtroom unprepared. After doing all the hard work of CCTV investigation and video retrieval, avoid getting caught up in a technicality such as playback incompatibility or a similar issue. Instead, think ahead and imagine anything that could potentially thwart evidence presentation plans, and also think ahead of time and plan ahead. We are going to discuss this in a way that we are moving from the CCTV control room. We have given the evidence to law enforcement. The evidence is in court. We have been called upon to testify against this evidence, and what should we have done before going to court. So it is a way that you have to prepare your material in advance. Preparing your material in advance is very important. Number two, conduct due diligence and simulate a live playback session at least a couple of days prior to the court day. Conduct a due diligence. This is to confirm that the video that you have is exactly what was captured on the system. The video that you are presenting to law enforcement or to the court has not been compromised, has not been tampered with. Rehearse and go through the exact steps you take when the court hearing is scheduled. Be advised that footage obtained from CCTV cameras is often saved in weird formats. Only specific software can open it. So don't assume it will just play on any computer. You may retrieve video, save it in a particular USB, but then when you go to play it in court of law, the format, the computer system, computer software doesn't accept it. So it is not, you cannot play it. Then the court will actually be stranded. Then verify if your forensic video enhancement software allows you to export the video footage to other formats that are easy to open on most computers and smart devices without installing additional codecs or specialized software. What we do, we mean to say here is conduct due diligence, rehearse, prepare, make sure that when you appear in court, your video will play, your video will be a true representation of what was recorded on the system and what you retrieved from the system. Conduct due diligence. Then also, don't compromise the chain of custody. Chain of custody is very important. Chain of custody is a way that we ensure the chain of custody is a way we ensure that the evidence is not tampered with by anybody before it reaches the court. To be admissible in court, it is important that a piece of evidence adheres to the chain of custody standards. In essence, this provides proof of its integrity and it's imperative to document who was left in charge of looking after it at any given time. Otherwise, its credibility could come under question. Chain of custody is very important in CCTV digital evidence acquisition, retrieval acquisition, and also before you present it to court. You make sure that it is secured, that nobody else who is not authorized comes into contact with this evidence. Otherwise, its credibility could come under question. In fact, a chain of custody should be established both visually as well as digitally. A skilled digital video forensics analyst will extract data from the source device and make copies without altering the original file. Still, it's important to document everyone who has come into contact with the evidence. Document everyone who has come into contact with the evidence. And then also, apart from chain of custody, present original audio and video recordings. If possible, present original footage to the court. Otherwise, it can be misrepresented. Even something as seemingly innocent as digital compression can jeopardize the authenticity of the video. The objective is to make an accurate reconstruction of events. A forensic expert needs to make sure that the footage is legitimate and authentic. Even so, there are cases where forensic video enhancement must be used for the sake of clarification. So in the field, you must be able to be working closely with forensic experts. In the police force, we have forensic experts. In the criminal investigation department, we have forensic experts. You must have contacts with these experts so that if there is a matter that is supposed to go to court, or you may even ask the court to give you guidance, the prosecutor to give you guidance. Ask the prosecutor, we have a footage of that event, but we need the help of a forensic experts to make sure that the footage is legitimate and authentic. Never assume things that you work alone and you present the evidence to court without ensuring that it will stand the test of time. In other words, you need a comprehensive all-in-one digital forensic solution capable of handling complex tasks such as video recovery, retrieval, enhancement analysis, all under one roof. This way, you won't have to worry about compromising the integrity of the recording. Another don't forget to bring playback gear with you. Many modern courtrooms are equipped with computers, speakers, and other multimedia devices. Even if they do have the IT gear, you could find out it's outdated and hence unsuitable for presenting the evidence with the level of detail you need, or it could break down in the time of need. At the very least, bring a laptop and a gained set of speakers, maybe a projector, if it's important for everyone to zoom in on the details. Get in touch with the court's IT staff and ask them what is available on site. But even so, technical hiccups do happen, often at unprecedented times. So it is important to bring backup. Don't forget to bring backup so that if something happens at the court and you are not able to play your video, then you can be able to play it. And this is very relevant even to law enforcement officers who may be with us in this training, police officers, forensic experts. Always go to court with a playback gear, your own laptop and your own video. You make sure that, and speakers, that you can play this footage in court as it is expected. Then also something that you must do, label the copies accordingly. Since you never know who's going to ask for a copy, make sure to have enough of them available to present on demand. Also, don't forget to label them accordingly. Study up on the exact requirements in your local area and make sure the sticker contains the correct information. One issue you could encounter when trying to do this is that you find out the sticker has larger dimensions than medium you are trying to mark, e.g. a flash drive. In this case, the solution is to find a transparent plastic bag that is big enough for you to fit the sticker on and place the storage medium inside. Storage media comes in different shapes and sizes. If it's too tiny, put a label on it. Place it inside a transparent plastic bag and put the sticker on top. Those are some of the procedures. The flash disks are usually very small, so you may find it is very difficult to label on it. The instruction is to put it in a plastic bag and then you can label the bag before you proceed to court. And then also another step, which is step 8. 8 steps to present video evidence in court. Now, sorry, we have come to 8 steps to present video evidence in court. What we were discussing above were do's and don'ts, what you need to do before you can start your journey to the court. Now, let's talk about 8 steps to present video evidence in court. Getting the pieces together and studying how to present video evidence in court can be a daunting task, especially if you've never done it before. Now, this is now courtroom best practice, but that is something you are going to have to get used to if in any way aligns with your job requirements. The good news is the process gets much easier once you have tried and a proven system in place. So, the 8 steps to present video evidence in court. Number 1, secure the evidence properly. Secure the evidence properly. Can we write something down here? So these 8 steps to present video evidence in court. Number 1, secure the evidence properly. Number 2, always maintain the chain of custody. Maintain the chain of custody. Who handles this evidence? Who comes across this evidence? Number 3, verify the authenticity of the video evidence. Verify before you can proceed to court. Verify, prove. We have seen cases where evidence has been tampered with. You go to court, you find that whatever you are presenting, you are trying to show in court is completely different from the true video that you intended to bring to court. And then sort the video evidence according to its relevancy, and then convert the video evidence to the right format so that it can be playable in court, and then review how to present the video exhibits in court, and then label the exhibits accordingly, and then prepare your presentation. Can we write something there? 8 steps to present video evidence in court. Yeah, so those are the 8 steps to present video evidence in court. Let's look at them one by one. Number 1, secure the evidence. Fail to do this part correctly, and the court may dismiss it based on improper procedure. Identification. Don't touch the evidence before identifying it. Document the entire process, including the location, digital forensic experts involved, etc. Collection. The objective is to physically collect the media that contains the evidence without altering its condition. So step 1 is secure the evidence properly. Step 2, still on step 1, accusation. By using the right digital forensic tools, a certified forensic examiner proceeds to make a forensic image, so the state of the original device can remain unaltered. And then preservation. This part is all about storing the evidence securely in a locker. And then analysis. Through the professional digital forensics, analysis we can reconstruct the events exactly as they occurred. If you are listening to me properly, it clearly states here that you as a CCTV surveillance officer or as a security manager, when it comes to presenting this CCTV footage in court of law, you need police assistance. You need police assistance. You need forensic expert assistance. These experts are authorized by law to handle this digital evidence. So all you need to do, you as a security manager or a CCTV security evidence officer, is to secure the evidence, secure the control room, make sure that you have the footage, then involve the forensic experts who are from the police force. Step 2, always maintain the chain of custody. This is a general pointer that applies to the entire digital forensic investigation. Technically, everything depends on this step. Failing to keep this in mind gives the opposing legal team great leverage to dismantle the entire case. The gist of it is to always keep bulletproof records whenever someone accesses the evidence in question, including events like analysis, transfer, collection, the identity of the investigator, date and time of events pertaining to it, purpose, examination, etc. So step 2 is always to maintain the chain of custody. I would also encourage you to read more about the chain of custody in CCTV digital evidence. Just look for the document. You can find it easily on Google. The meaning and the relevancy of chain of custody in CCTV digital evidence. Also, the golden rule is to document everything and make screenshots when necessary. Never work on the original to avoid having its legitimacy come under question. Make a copy instead. Step 3. Verify the authenticity of the video evidence. Before bringing the video evidence before the jury and the court, make sure it's authentic and legitimate. In other words, rule out the possibility of it being manipulated, tampered with, or a straight out fake. In addition, video evidence in court can only be admitted if it is an accurate representation of the events that occurred. It proves that a crime has taken place. It is relevant to the case. A good trick to use is to take a screenshot of one of its frames and use tools like Google reverse image search and ThinkEye. These are some of the steps you may take. The issue here is the information in simple short is that verify the authenticity of the video evidence. Verify the authenticity of the video evidence before you can present it to court. Remember, number 1, we spoke about. Number 2, we spoke about. Number 3, we spoke about. Number 1, we spoke about the issues of protecting the evidence. Number 2, we spoke about chain of custody. Number 3, we are talking about verification. Number 1, remember the procedure. You have to follow the correct procedures. Number 2, remember chain of custody. You have to follow the correct procedures also in chain of custody. Number 3, to verify. Follow procedures in verification. Make sure that what you are going to present is exactly what it is supposed to be. Another method a video forensic analyst may use is to slow it down and watch it in slow motion. Awkward looking transitions are usually a dead giveaway. The video has been tampered with in some shape or form. Don't forget the power of checking its metadata. This can give you valuable clues pertaining to its origin, including where it was shot. Then all you need to do is to enter the coordinates obtained into a geolocation tool like Google Earth, and answers you are looking for should be there. As a final pointer, you should also check whether the date and time displayed in the footage are correct. This is a major mistake that happens in many court of laws, that you present evidence and the date and the time that relates to the case is completely different. Then that one becomes irrelevant evidence. Also, we say step 4, sort the video evidence according to its relevancy. The best approach to how to present video evidence in court is to make sure that whatever materials you present to the judge can serve as proof and don't waste time. For example, if a video, something happened at 1500 hours, up to 1515 hours, you should not present to court the evidence, a video footage from 1300 hours to 1700 hours. Concentrate on that particular time, plus or minus few minutes from the start to end. Just be relevant so that it doesn't waste the court's time. For instance, don't bring the entire 10-hour CCTV video footage. Pick out the interesting bits instead, the ones that are relevant to the crime taking place. Arrange them into a hierarchy from the most to the least important. To illustrate an example, a clear recording that shows the criminal's face and the crime committed from a practical angle would be the obtainable evidence that is required by the court. Concentrate with what is required by the court. Don't go into so many details. There are security managers, there are CCTV security officers, even in report writing. Sometimes security officers, sometimes surveillance officers, we write reports that are outside the context. Something has happened, instead of going straight to the point, you start from a very far distance, trying to analyze things that are not relevant to the matter. You end up submitting a report that doesn't even make sense. This report cannot stand the test of time. Then it puts your integrity, your competency into question. 5. Convert the video into the right format. We spoke about that. Ensure that the video can be played in court on any system. And without even ensuring it can be played in court on any system, carry a backup, a laptop that you can use to play in the court. So convert the video evidence into the right format. And then 6, review how to present the video exhibits in court. Consider studying one of the court's previous hearings to get an idea of how the procedure works. This should give a solid idea of how to prove your case, present a list of exhibits, summarize your points, conduct yourself professionally before the judge, call your witnesses to the stand, and cross-examine the other party's witnesses. I can tell you, as a CCTV surveillance officer, even if you are not in the law enforcement, you may find yourself in this situation. You are in court of law and you have to follow these procedures. And then also respond if the other party raises an objection to the video evidence presented. Explain what the video evidence represents. State that you have observed and analyzed the video footage. Testify the fact that the video evidence presented is genuine and is an accurate representation of what happened. And then also step 7, label the exhibits. We spoke about that, labeling the exhibits and enclosing them in a bag if they are small in a sticker. Label the exhibits. And then number 7 still, don't forget to bring extra copies to make sure you can offer a copy to anyone who may ask for it. The judge, the jury, and the opposing legal representation, it's recommended to bring copies on multiple storage media with you. Consider transferring the files to CDs, DVDs, flash drives, memory cards, and the cloud to have storage also and backup. Also, step 8, which is final, prepare for your presentation. It is the day to go to the court to present your evidence. Organize all materials, list them, and don't forget to bring extra playback gear, just in case the court doesn't have it on site. Apart from the exhibits themselves, carry the necessary paperwork. The obvious thing that comes to mind is the chain of custody. Logs. Also, in case the video contains any dialogue or spoken word, don't forget to bring the official transcript as prepared by a certified professional. For the convenience of the judge and the legal personnel, mark who is speaking every line and append the exact time stamps next to that. Finally, don't forget the psychological part of the trial preparedness. prepare psychologically for the case. It is usually a tough moment. You have seen some witnesses who are law enforcement in court of law, and they cannot even speak in front of the judge and in front of the prosecutor. They cannot give the evidence. You reach the court, and then due to shock and maybe panic, you go into panic mode, and then you cannot present the evidence. That is why we say it is important to prepare yourself in advance, to do some kind of a rehearsal in a room by yourself. Do some kind of rehearsal how you present yourself in court. This is very important. I have detailed some steps that are very necessary to preparing digital video evidence, from what can be admissible in court and what cannot be admissible in court, up to the steps that you may need to carry. And finally, we have spoken about the psychological part. Prepare yourself psychologically to face the court, to present the evidence, and to make sure that you win the case. With those very few remarks, I say thank you very much. When your time comes to go to court, best of luck. Remember these simple best practices in preparing CCTV digital evidence in a matter that is coming up in court when you are involved. Thank you very much. See you another day.